Hi, I'm Paul Menace. I'm an entertainment lawyer in Los Angeles, and we're in my office at Tyre Kamens Katz Granoff and Menace in the Century City portion of Los Angeles, which is where a lot of entertainment lawyers tend to be. I played a couple of different instruments and wrote songs and performed at clubs around Los Angeles, basically a singer-songwriter, and thought I might have a shot at earning a living at it. And Barry, my older brother, who's been my law partner for 24 years now, was practicing entertainment law and impressed upon me the odds against me becoming the next Elton John, and that I could sort of be near what I liked and be in the industry I liked without really having to have any discernible talent. So I thought that was a good idea. Gave myself about a year and a half to try and make it, and when the year and a half was over and I was no closer to making it than I was at the beginning of the year and a half, I decided law school was a good choice and I could eventually, hopefully, practice entertainment law. Now in law schools they actually have entertainment law classes and programs, but I knew it was a field of law that I could practice in, and you're right, there was a copyright class and there was a contracts class, but there wasn't a formal curriculum for entertainment law. But I felt with my background and the fact that even in the studios, a lot of guys, the guys I was playing with, would hand me contracts to look at because I was one of the only college graduates, doing any kind of studio work, at least in my small circle of people that were, dumb enough to hire me to go in and do studio work. So, I had a little bit of an idea of what it was about, and I just tried to sort of keep that in my mind as a goal to get to once I got out of law school, if I could. Trademark is basically a monopoly that the federal government grants to identify where something comes from, the origin of something, either a good or a service. The common name for trademark now is branding, which is really all it is. It is the brand you attach to the goods you make or sell or the services you offer so that people know they come from you and it distinguishes you from everybody else doing the same thing. They're very valuable, and it's gotten more valuable and more important as time has gone on. And I started doing it as an adjunct of the entertainment stuff because bands, artists, started to in the past and now always are told to protect even their own names, but their band names, so that nobody can rip them off or do things under their names or basically trade on their fame or their talent. Trademark basically stops at all the borders of the countries, but there's treaties between the United States and other countries, and there's this overarching treaty called the Madrid Protocol, which in English basically means that you can register your mark in maybe a couple of places and cover most of the world, whereas in the old days you had to go country by country. And there was sort of an intermediary step called the community trademark, which was basically in the EC, but this relatively new treaty the United States joined makes it simpler, easier, and a whole lot less expensive to get cross-border protection. The biggest issue, or the remaining big issue, is with the internet, where they changed the law recently, the trademark law, but it used to be, and people made fortunes when the domain names first became available. They would rush and register famous domain names, Pepsi.com, Chevrolet.com, whatever.com. And when the companies would try and, register these names so they could go online, they were taken. And for a while, these people, these cyber squatters, would sell back the names, the domain names, to the actual companies, and actually did quite well for a while. And then lawyers like me, or trademark attorneys, intellectual property attorneys, started getting involved and saying, wait, that's not fair. There's got to be a way we can prevent this, or at least try and lobby to have the law changed. And eventually they passed a law, which is an anti-cyber squatting provision, where you're no longer allowed to register a domain name, pretty much just to reserve it, take it out of circulation, or deprive the actual company whose name is in the URL from using it. We were one of the few countries for years and years that didn't have a performance right, in other words, a performance royalty that would flow to the owner of the sound recording. During the negotiations to change the laws, the copyright laws, when the Digital Millennium Copyright Act was passed and its predecessor was passed, part of the give and take was there is now a performing right for sound recording owners for digital performances. And the internet being a digital medium, that's where that applies 99% of the time. It happens somewhat, well, it happens on satellite radio because that's also a digital delivery system. And there's a little bit of an argument among some people, not among others, that it should also apply to terrestrial radio now because terrestrial radio, people are arguing that because of the nature of what is being broadcast, it's now become digital and there should be a performance, but it's not really. I mean, terrestrial radio is still, as of right now, an analog broadcast. It really hasn't changed completely or wholesale yet. The music business has followed the same business model since piano rolls, practically, and weren't real fast on the uptake when Napster first came along and people started trading music for free on the internet. Granted, it's hard to turn a battleship on a dime, and they're very large companies, and they had done things for a long time a certain way, and they just, it was brand new technology, and it's easy to look back in hindsight, but for whatever reason, they didn't see it coming, they didn't realize it was going to be a huge issue, and that it was going to be sort of the equivalent of the Industrial Revolution all over again. People were going to consume entertainment a completely different way. The technology was going to change everything. So the music business lost a lot of money, contracted quite a bit, and of course started scrambling around to try to figure out how to stop the pirates on the internet and how to, make money from the new technology. So everybody is angling for the biggest piece of the pie they can possibly get their hands on, and in order to grab that piece of the pie, they're using whatever resources they have, the revised copyright law, old copyright law, logic, no logic, to claim they're entitled to this much of that pie because. And it's a tremendous fight. And every time the technology changes a little bit, the fight moves a little bit. I mean, the labels blame the publishers blame the labels, the artists feel like they're, again, getting hung out to dry to some degree and not participating as much. But the technology keeps changing. It's actually probably changing a lot faster. Well, it's definitely changing a lot faster than the law is. The last major change in the Copyright Act, the Digital Millennium Copyright Act, was probably obsolete by the time they passed it, and it doesn't cover a lot of what's going on now. The legal issues are basically, what rights do you have to get to deliver media to consumers over new media, and how is the money split up amongst these rights between the various rights holders and participants? It's the Wild West all over again. There are no true rules for this except the old rules, and the old rules don't really fit well, in what's going on. And part of that reason is the mindset of a lot of people in the industry. They only have one frame of reference. It's the frame of reference they've grown up with in the industry, which is how things were before for years and years and years. And it doesn't fit easily into how music and other entertainment is being consumed now. I mean, just in the last couple of weeks, for the first time, NBC Universal and Disney agreed to license certain of their, I hate to say content, it's a buzzword that everybody uses, but certain of their entertainment programming to iPod, to Apple rather, and to certain video-on-demand cable or satellite systems, so that people could, on the iPod, actually have something to watch on their video iPods, and on satellite and cable boxes and subscribers, so they could watch what they wanted to watch when they wanted to watch it without having to worry about pre-programming something on the TiVo so they could save it for later. They were always deathly afraid of doing this. They thought it would cannibalize revenues from advertisers. That was the bread and butter of television especially. They thought it would lose something on the small screen. They were afraid people would zip through the commercials and not watch it. But the industry is slowly catching up with the technology and the appetite, which is people are consuming things a whole lot different now than they ever did, especially the major demographic of entertainment consumption, which are, I think is 12 to 25, or depending on who you talk to. It's basically children and young adults, and they have to figure out a way to make money from their entertainment programs. I mean, people argue about everything, but it is absolutely a given that more people today are consuming more entertainment content than at any time in recorded history. The problem is a lot of them are doing it for free, so nobody's getting paid, and they're doing it in ways that are completely foreign because the technology is so new. You know, everybody makes a big deal out of iTunes. They've sold, you know, 1 billion or 5 billion, I forgot the number, downloads so far, but that many times 10 is what's traded for free on a daily basis on the internet. One thing iTunes teaches, I think, is that people will pay if something is easy. That's why there's now video being licensed from networks for video iPods. That's why people are willing to pay for free network television shows like Desperate Housewives. You know, when they want them, people will pay for convenience. So if you make it attractive enough and you make it easy enough, people don't have a problem paying for it. I mean, when peer-to-peer started, it was, and it still is, very easy to use those programs. I don't know if you ever tried when the first pay services came out around the same time Napster came out, like Press Play or iMusic or eMusic, I forgot. They were impossible. Yeah. They took forever. They were very frustrating. They weren't intuitive, and people bailed. They said, you know, screw this. I mean, we can get it for free, and it's easier. And so what needs to happen is everybody sort of has to cooperate to come up with a revenue model for the technology that everybody is now consuming entertainment programming on, which is cell phones primarily, you know, and certain kinds of PDAs in their computers. And it's moving in that direction really fast. A lot of the owners of the stuff, the publishers, the record labels, are traditionally afraid to make deals because either they want to wait till somebody else does it or they're afraid they'll set a precedent. But nothing is cast in stone, and everything's changing so quickly. I think they're losing the ability to generate revenue from their stuff in these new ways by not taking that first step, by not saying, okay, just for now, we won't take X cents per song. We'll take a third of X, and we'll see how that works. But in a year, if you guys are making 15 times more money than we are, and we don't think, you know, your element of the intellectual property is any more valuable, we're going to come back and revisit it. But there's got to be that willingness, and the more, you know, innovative executives in the industry come to realize this, and it's starting, the faster it'll catch up, and you know, the revenue model will be different. It's not going to be the same. Whether they'll earn as much or not, I don't know, but it seems to me there's a whole lot more ways to make money from the consumption of entertainment programming and other programming out there than is being addressed quickly enough. Well, according to this article in Billboard, the most recent one, for ringtones, the carrier, the phone carrier gets 40%, the artist gets 20%, the label gets 20%, the publisher gets 10%, performing rights is about a 5% hit on that, and the hosting service gets another 5% of the, you know, basic ringtone price, which is probably these days around $1.99.
Who sets those percentages?
It's negotiated. When the carrier wants to carry it, they have to negotiate with, you know, the record company, the artist, the publisher, to be able to license those master ringtones, those recordings, for this particular purpose. So they get a license from all of these rights holders, and then probably have to lay off some of their revenue on the hosting company to, you know, digitize it and make it available if they don't do it themselves.